What does it look like when someone decides a courtroom has no authority over them? What does it look like when that decision survives 4 months of filings, 24 denied motions, and finally the witness stand? What does it look like when it ends? I have spent 22 years in the same building, 9 of them representing the people in that chair, 4 of them arguing for the state, 9 of them sitting on the bench above the room I had already occupied from every other angle. I have watched the full arc of what happens when someone walks into a proceeding believing the proceeding does not apply to them. I have watched it from all 3 chairs. My name is Catherine Merrill, and I am going to tell you something that most people in this profession will not say in public. The framework he brought into my courtroom was not a legal argument. It was a clock. And the plaintiff on the other side of that room had been watching it run for 14 months. If something in that lands, if you have ever watched someone use procedure as a weapon aimed at the wrong person, subscribe and hit the bell. What I bring here took too long to earn to deliver any other way. And in the comments, write something about this case you couldn't say in public, the thing you recognized. This is the place for it. Come back with me to that room. Here is what I saw when I walked in. He walked into my courtroom the way some people walk into a room they already own. And I want to tell you about that walk because everything that followed was already in it. It was a Thursday morning, the kind of Thursday that arrives with nothing to distinguish it on the outside. The kind of morning where the bailiff has already made his second coffee, and the clerk is sorting exhibits with the efficiency of someone who has done this 10,000 times. I had been on the bench for the better part of 2 decades by then. I have had the kind of mornings that teach you what a day is going to be before the first sentence is spoken. And when he came through that door, I understood something that I want to try to put into precise language, because the word that comes first, arrogance, is not quite accurate. It was not arrogance. Arrogance implies a level of awareness about the stakes. What I saw when he walked through that door was something I have seen before, in cases with higher dollar amounts and fancier suits and better haircuts, but always with this same specific quality, the absolute, undisturbed certainty that this room was a formality. Not that he would win, something more complete than that. The certainty that this proceeding was something happening to him rather than something happening because of him. He looked at me the way a passenger looks at an airplane seat, briefly, assessing comfort, and then looking away. He did not look at the plaintiff. I noticed that. I noticed those things. After 9 years representing people in that chair and 9 years sitting on this bench, I have learned to read the room before the room reads itself. The plaintiff was seated to my left, where she had been seated every session of this proceeding for 14 months. She had come every time. She had prepared every time. She had watched him file motion after motion, each one more elaborate than the last, each one requiring her to wait in this building while I read documents that she knew, and that I knew, had been written not to make an argument, but to exhaust one. She looked at him when he came in. He did not look at her. That asymmetry, that is the whole case right there before a word of testimony. Let me tell you what had brought us to this room. The underlying dispute was not complicated. It did not require a legal education to understand what had happened or what was owed. He had entered into an obligation. The obligation had not been met. The plaintiff had a claim. The record supported the claim. There were documents, there were dates, there were numbers that told a story that was, on its own, entirely straightforward. What made the case what it became was not the underlying dispute. It was what he decided to do with the proceeding. I received his first filing approximately 3 weeks after the matter was assigned to my docket. I read it the way I read everything, completely, without forwarding the summary to my clerk and relying on her interpretation. I read it because I have been in rooms where the summary did not tell you what the document actually said, and I have learned not to trust the shortcut. I read it, and what I read told me several things about the months ahead. The filing was 12 pages long. It was formatted with his name at the top in a particular typographical style, all capital letters in one place, then a specific hyphenation pattern in another that I recognized. It argued, in language that had been assembled from various corners of the internet and from legal documents the writer clearly had not been trained to read, that this court did not have jurisdiction over him because he had not consented to its authority. It cited documents that do not carry the legal weight he attributed to them. It invoked a version of common law that bears no relationship to the law as it is actually practiced in any courtroom I have ever sat in. And it was signed at the bottom with a notation that described him as a, quote, natural person, unquote, which he had apparently decided was a legally meaningful distinction from whatever other kind of person he believed the rest of us to be. I denied it in 2 paragraphs. The second filing arrived the following week, longer, more elaborate. The same framework, now supplemented with a demand that I produce my oath of office on the record before proceeding. The third filing questioned the validity of the court's seal. The fourth was a motion to recuse me on the grounds that I was an agent of what the document described as the corporate government, rather than the lawful common law court he had determined this case required. I denied each one. Each denial took less time than the filing it answered. But here is what I want you to understand about the mechanics of what was happening, because this is the part that does not make it onto the record in the way it deserves to. Every filing required a response. Every response required the plaintiff's attorney to appear, to review, to prepare. Every scheduled hearing that was delayed by a pending motion was a day the plaintiff came to this building and went home without resolution. The time was not abstract, it was specific. It was mornings the plaintiff had arranged her schedule around, calls she had made to her attorney, hours of her life that she had organized around the question of when this proceeding might move forward. I have sat in the chair on the other side of that table. I know what those mornings cost. He had come to this room with a strategy. The strategy was not to win. I want to be precise about this because it matters for everything that comes next. The strategy was to make the room impossible, to flood the docket with filings that required attention, to invoke a framework that sounds, to someone who has not read what I have read, who has not spent 9 years in the public defender's office reading every piece of paper in the file before walking into a courtroom, like it might be legally serious. The sovereign citizen framework is not legally serious, but it is time-consuming, and time in a civil proceeding is a resource that is not equally distributed between the person with the claim and the person working to exhaust that claim. This was the thing I knew before he walked through the door, and then he decided to testify. I want to sit with that decision for a moment, because it is the one that defined everything that followed. He had been representing himself throughout the proceeding. This is his right. I have had pro se defendants before. I have been a pro se defendant's attorney before, which gives me a particular kind of fluency in what that position looks like from the inside. There is a meaningful difference between a person who cannot afford representation and is doing the best they can with what they have, and a person who has decided that no attorney is needed because the court has no authority over them anyway. I have seen both. I can tell them apart before the first sentence is spoken. He was the second kind. When he informed me that he would be taking the stand, I noted it for the record and asked him to confirm that he understood his right to remain silent and his right to testify. He confirmed it. He did so in the particular way of a man who has decided that this is the moment, that the stand is where he will finally explain, in his own words, what this court had apparently been too obtuse to understand from the filings. He was settled when he sat down, composed. He had the papers in front of him. He had the framework. He had the language he had spent months developing. From where I sat, I could see the top sheet of his notes, which he had not attempted to conceal. It was a series of bullet points. The first one read, "Establish Jurisdiction Challenge." I watched him prepare to explain to me what my courtroom was. The first question from opposing counsel was straightforward. A date, a number, a transaction. The kind of question that has one answer if you are answering honestly, and requires an architecture of evasion if you are not. He did not answer it. He looked at opposing counsel the way I have watched defendants look at questions they have decided are invalid, and he said, and I am going to give you the exact words because they are the entire case in one sentence. He said, "I do not recognize the authority of this proceeding to compel a response." The room had a particular quality after that. I have been in rooms where something becomes irreversible and everyone in the room understands it simultaneously. This was that room. The plaintiff looked at the table in front of her. Her attorney set down his pen. The bailiff, who has worked with me for 11 years and who I trust to read a room as well as anyone I know, looked briefly in my direction and then looked away. I let the silence sit for a moment. Then I said, "The proceeding compels a response. Please answer the question." He did not answer the question. He produced instead a document from his papers, a document he had apparently prepared for this moment, and began to read from it. The document was a declaration of his status as a sovereign individual not subject to statutory authority. He read 3 sentences before I asked him to stop. Here is what I want to tell you about what happened next, because this is the part that the transcript captures but does not fully convey. I did not raise my voice. I have not raised my voice in a courtroom in a very long time, because I learned early, in the public defender's office, in rooms where my clients' lives depended on the quality of my presence, that volume is not authority. Authority is what you have before you open your mouth. I set down the pen I had been holding. I looked at him, and I said, "You are under oath. The oath you took does not have a jurisdictional clause. Answer the question." He answered the question. The answer contradicted a statement in his 3rd filing. Opposing counsel noted the contradiction, asked a follow-up. He answered the follow-up. The follow-up answer contradicted the first answer. Opposing counsel, patient, prepared, the kind of preparation I recognize because I have watched it from 2 sides of the table, walked him slowly, without any apparent urgency, through the architecture of what he had built. Each question placed one filing against another. Each answer produced a new inconsistency. He was not lying in the way people lie when they know what the truth is and are choosing something else. He was doing something I find, if anything, more revealing. He was telling the truth as he had constructed it, and the construction was collapsing under the specific weight of chronology and documentation. There was a moment, and I want to be exact about when it happened because it is the center of everything, when opposing counsel placed 2 documents side by side. One was a filing from month 3 of the proceeding. One was a communication that predated the filing by 6 weeks. Together, they told a story that the filings had been specifically designed to obscure. He looked at the documents. I watched him look at them. I have watched people look at evidence that contradicts them for 22 years, and there is a particular expression that crosses a face when the calculation shifts, when it stops being about the truth and starts being about what is survivable. I saw that expression. He tried one more jurisdictional objection. I overruled it. 2 words. No elaboration. He sat in that silence for a moment. And then, for the first time since he had walked through my courtroom door 4 months earlier, he answered a question without the framework. Just an answer, just words. Just a man in a chair, under oath, with the documents in front of him and no sovereign theory left to stand behind. That is what I want you to understand. Not the filing, not the obstruction, that moment. When what he had believed about this room, that it was a formality, a stage for a performance he had written and would control, turned into what this room actually is, a place where the record is made, a place where documents talk to each other across time and do not care about the framework you brought in to manage them. I want to tell you what I thought about in the moment before I delivered the ruling. I thought about the plaintiff. I thought about 14 months. I thought about the specific quality of a morning when you wake up knowing you have to go to a building where someone is going to try again with new paperwork to make what happened to you disappear. I have sat across from people who have had those mornings. I have been the person they were counting on in earlier parts of my career to walk into that building with them, and I have been for 9 years now, the person in that building who decides what the record is going to say about those mornings. The ruling was not close. It was not close in the way that a case that has been buried under procedural filings for 14 months sometimes appears close from the outside, where the volume of paper creates an illusion of genuine dispute. From where I sat, with the complete record in front of me and 22 years of reading records behind me, the case had been clear since the second week. What the 14 months of filings had accomplished was the consumption of 14 months. That is what they were designed to do. That is what I said in the ruling, not in those words, but in the precise language the record required. I named what had happened, I named what it had cost, and I ruled accordingly. He did not speak when I delivered the ruling. He sat very still. I have watched defendants receive rulings in many registers: anger, disbelief, tears, the specific blankness of someone who had never genuinely believed the outcome was possible. What I saw on his face was something I have seen before, and it is the thing I find most instructive about cases like this one. It was not outrage, it was confusion. The genuine, undisguised confusion of a person who had believed, completely and without reservation, that the framework he had constructed was sufficient, that the room would eventually yield to the theory, and the room had not. The room had been itself all along. He had just spent 14 months not quite seeing it. There is something I want to say before I ask you anything, because I think it belongs before anything else. The plaintiff in this case got what she came for. I want to say that clearly, and I want to say it first. Not quickly, not without cost. She spent 14 months of her life in this building and in the anxiety of waiting that surrounds a building like this, and she arrived at every session prepared and present and without the performance of certainty that was being staged across the aisle from her. She did what the proceeding required. She waited. She documented. She answered every motion with patience and with a record that did not require a framework, because the record was sufficient on its own. I want to name that before anything else, because it is the part of this case that deserves to be said out loud. She did the work, and the work was enough. It was enough. That matters. I have been thinking about this case, as I tend to think about the ones that demonstrate something with particular clarity in the days since the ruling. And what I keep returning to is not the framework itself. I have seen it before and I will see it again, and its legal validity does not improve with repetition. What I keep returning to is the calculation of time, not as a metaphor, but as a literal accounting. 14 months, the hours of the plaintiff's morning before each session, the hours of her attorney's preparation for motions that had no merit but required responses, the hours in the waiting room, the hours in the car home. This is what the strategy consumed. These specific hours of a specific person's life used as a mechanism to avoid an obligation that the record had supported since the beginning. I want to ask you something tonight, and I mean tonight specifically. Before the day closes, think about the cases in your own life, not courtrooms necessarily, but rooms, workplaces, families, institutions. Think about the times you have watched someone consume time as a strategy, someone who has learned that if they make things complicated enough, elaborate enough, procedurally exhausting enough, the person with the legitimate claim will eventually run out of resource or will. Think about whether you have been the one waiting. Think about whether you have been the one filing. And if you find something in that inventory that gives you pause, write it in the comments. I am asking because this case put a name on something I want to hear you name too. What did it look like where you were? What did it cost? I read every one. If what you heard today resonated, if this is the kind of account you want to keep returning to, I would be glad to have you here. Subscribe and hit the bell. What I bring to this channel is what I brought to that bench for 22 years, the record as I saw it, from every chair I have occupied in this building, without softening the parts that require the full weight of what actually happened. This case is concluded. The record exists. The plaintiff went home. That is enough for tonight.